Good morning, everybody. I think I'll make a start now. There's quite a lot of people in the Zoom. I'm Stuart Benzie. I'm a barrister at Radcliffe Chambers. And this morning, as you can see from the slide, I'm going to talk to you about unfair prejudice. I am a commercial barrister. I joined Radcliffe fairly recently. My practice involves a significant amount of unfair prejudice claims, along with fraud, general commercial disputes, and some high court employment work, restricted covenants and confidential information. I had prepared a talk, which is the one that was heralded in the message that went out, where my intention was to go through a brief introduction to the history of unfair prejudice, followed by an overview of the core concepts. And then I was going to do a case study, which, as you will see, was based on situations where directors have been deprived of their shares, arguably unlawfully. Now, I've changed that because, as many of you will know, the Court of Appeal handed down a decision in the Koinomi case this day last week, and that is an unfair prejudice claim. It deals with a very specific point on the overlap between unfair prejudice and derivative claims. However, that point of itself is interesting, but also in terms of a case study, it's almost a classic unfair prejudice claim, relying on two of the most common basis of unfair prejudice: exclusion from management and misapplication of the company's assets and related fiduciary duty breaches. So what I'm going to do is start with a brief overview. I'm not going to speak for too long about the history of the origins of the oppression remedy, then go on and talk through Section 994 of the Companies Act, with which I'm sure everybody's familiar, but then talk about the fundamental concepts, what it is you need to show that a company is being operated in a way that is unfairly prejudicial to one or more of the shareholders. And then we'll finish the talk by looking at Koinomi, having a look at the facts of that case, and then considering the judgment and looking at it in the round, because I think it's an interesting case, and I certainly think it's a case which has potential to go to the Supreme Court. It's also worth looking at Koinomi because you don't get that many unfair prejudice claims in the Court of Appeal, so a Supreme Court case would be quite interesting. I was trying to think of a joke to start with, and I was lying awake last night trying to think of an unfair prejudice related joke, and I failed miserably. I didn't come up with anything that I'd be willing to say out loud. So I'm going to start with the words of a singer-songwriter, Martin Joseph, which is an actor is only a performer is only as good as his audience. And hopefully this morning will be wonderful. So the origins of unfair prejudice. The reality is that the problem of situations, corporate and otherwise, where a minority may be oppressed by majority, goes back as long as time itself. And as I've set up this slide there, the origins of modern unfair prejudice law can be traced back to the codification of Roman law under the well-known Emperor Justinian. This is discussed by Miss Justice Briggs in the Assignon, if that's the correct pronunciation, asset management case. The theme of that, which is set out on the right, was carried on through the 19th century. And you'll see that general principles of ancient origin. And basically, it's when you look at what's going on, it traces very much into modern law, because when we go on and look at 994, as it stands today, it is very much an equitable remedy, and those elements of equity, unconscionability, are still, to a greater or lesser degree, depending on the type of company you're dealing with, at the heart of unfair prejudice. So moving on to how we got to the current Section 994, and I'll just pause briefly. Somebody's asked me, will the slides be circulated after the presentation? And the answer to that is yes. And I'll arrange to have that done when we've finished. There's always been a remedy for the oppressed minority, and traditionally that remedy was just and equitable winding up, or something akin to a just and equitable winding up. Now, obviously, just and equitable winding up is still a remedy that's available in the courts today. However, obviously there are problems with a situation where, if you are an investor in a successful company, it may be the last thing you want is to have that company wound up. And when we look at Koinomi later, you'll see that's a classic example of where the petitioner so I was muted there briefly. He wanted to carry on with the company. And of course, just and equitable winding up can be very expensive. It can be time consuming. And under the modern unfair prejudice laws, the courts are loathed to wind up an otherwise viable or indeed successful company. So what happened was, in the 1948 Companies Act, there was the first attempt at some sort of statutory remedy, which was Section 210 of the 48 Companies Act. I say I did some work in Hong Kong a while ago, where I had the joy of working with the 1948 Company Act. The word used for what we now call unfair prejudice in the 48 Act was oppression. And that led to more problems really than answers, because what happened was there was some doubt in the old authorities as to exactly what oppression meant. And it resulted in courts taking a very restrictive approach. So what happened was that whereas the idea of oppression of the minority came in as an answer to not wanting viable companies wound up, you ended up with a situation where winding up was still the easier option, and it was very difficult to get a remedy under the Section 210 remedy. That went on and was recognised in the Jenkins Committee report. It's probably worth saying that, as much as that's a very old report now, it's still actually interesting to read, because it recognises a lot of the problems that were certainly very important then and remain important today. And it's also, when you look at the laws in other jurisdictions, particularly places like Singapore, Malaysia, Cyprus, the laws there on unfair prejudice are heavily influenced by the Jenkins Committee report. Now, what the Jenkins Committee recognised was what I've just said, that oppression wasn't a very helpful word, and there was considerable doubt as to what was and wasn't available under the Section 210 remedy. And the Jenkins report recognised that people were still winding up companies, or attempting to wind up companies, that were otherwise viable and profitable. So what it did was it recommended the use of the term unfair prejudice. So this is 1962. So the legislative, acting with the usual speed that they do, eventually implemented unfair prejudice in Section 75 of the 98 Act, so only 18 years. So we probably applaud them for that. So this was the first adoption of the term unfair prejudice. That went on to become Section 456 of the 1985 Act. And the things that are notable in that, because essentially what we have now is the same as the 85 Act, the perhaps surprising decision to deliberately use imprecise language. And one of the themes that we'll see as we work our way through the remedy itself is that there is a very wide discretion. This is intended to be, and is, a very broad remedy, which can provide a very broad range of relief in very many situations. It grants, certainly in my experience looking at company law and the other areas of law I'm involved in, probably a wider degree of discretion to judges in anything other than in injunction type jurisdictions. It's a very broad matter. So that took us on to Section 994 of the Companies Act. So looking at what Section 994 actually is, that's the subsection 1 of subsection 994. Now, unfair prejudice sits across a number of sections in the Companies Act, but the two that are important for today's purposes are this section 994, which I say isn't there in its full. There's more to it than that, but this is the important part. And we'll look at section 996, which is the provision which grants the court jurisdiction to grant relief. And we'll see there's a commonality there in terms of the way it's worded. So you can see I've highlighted what I would say are the core issues that we'll need to look at. And what I intend to do is work through those in the next section and look at what exactly it is a litigant needs to do when they petition for unfair prejudice. I've set out the test there in 4 headings. The first, you need to be a member of a company, and we'll go on to see what member of a company means. The second, that the acts or omissions that are complained of must be management of the affairs of the company. And related to that is the third, which is that the conduct of the affairs must cause prejudice to their interests as members, not in any other capacity. So the classic situation, you very often have situations, I have 2 cases going at the moment, where in parallel there are employment proceedings. So it's not uncommon, for example, for 2 investors to start a company. Both of those investors are often, as a consequence of the agreement between them, are entitled to be engaged in the management of the company. And so they both become directors and employees. And when they fall out, the first element of the falling out is often an unfair dismissal claim, which then segues into a 994 petition and potentially wrongful dismissal claims in the High Court. And then finally, that the prejudice suffered is unfair. And as we'll see, we'll go on, when we talk about unfair prejudice, there are 2 distinct elements. You have to have prejudice, and we'll look at what that means, but it also has to be unfair, and it's possible to be prejudiced in a way that's not unfair. The one point which I haven't highlighted and haven't really developed is what is a company, and that's obviously quite an important point. The starting point is that a company, for the purposes of Section 994, is a company as defined in Section 1 of the Companies Act 2006, and that essentially means a company that's incorporated under that act or its predecessors. 2 points of interest there. One, notably, doesn't include unregistered companies, as you see primarily the insolvency legislation. And then the second point is that LLPs are theoretically covered by Section 994, and that's as a consequence of the 2009 LLP regulations, which introduced exactly the same provision for LLPs. However, what it also introduced was an ability for LLPs to carve out this particular form of relief. And certainly in my experience, and certainly in the major textbooks, they say that it's almost invariably the case that when you look at an LLP, they will have excluded the member's rights to bring a petition under 994. That said, I've been involved in a long-running dispute, which perhaps surprisingly involves a law firm, where it hasn't been excluded, and we are at the moment on the verge of 994 petitions. So it is possible in an LLP, but it's also unlikely. So that's the starting point and what we need to look at. So if we move on and say, well, who is it that can petition? This is a slightly busy slide, but it's a way of saying there are really 2 groups. The first group are members, and the second group are transferees. Members means probably what you think it means, and it's as defined in Section 112 of the Companies Act 2006. So the first is subscribers to the memorandum. Well, that's straightforward. And then people who've agreed to become a member and entered in the register of members. It's not strictly the right description, but if you think of it in terms of legal and beneficial owners, it's the legal owner of the share that has the standing to bring a 994 petition. That's probably a good guide. So, for example, a bare nominee has the right to bring a Section 994 petition, whereas a beneficiary under a trust doesn't. There is, and obviously remedies in trust are not the subject of this talk, but there is an argument you could, as a beneficiary, join the trustee and bring it as a derivative claim, but that's for another day. The other group of transferees, and the petitioner must show that he's agreed with an existing member for the transfer of shares in the company to himself and that a proper instrument in respect of those shares has been executed. That also includes people who've had shares transferred to them by operation of law, so through wills, through the operation of the Articles of Association and so forth. But as I've alluded to in talking about that, the key points here are the two at the bottom. One is beneficial owners have no standing, and secondly, former members cannot petition. Now that raises one particular issue, and as I said, when I set out the talk, I was going to talk more about the position of a director who has their shares removed, and I'll talk about it briefly now. The situation's not uncommon that when somebody is a member of a company and they are also usually a director, that they can at some point be removed. And many of you will be familiar with the concept of good leavers and bad leavers. And very often, if you're a bad leaver, you can be forced to sell your shares, often at a not very attractive rate. And it's also often the case that very often, either in the articles, but more commonly in a shareholders agreement or something akin to a shareholders agreement, that there will be a power of attorney which will allow the other shareholders to transfer your shares for you. So what's the position if you are, for example, unfairly dismissed and you find yourself in a situation where you've been excluded from management, maybe other things have happened in the company, but your shares have now been transferred to another party and you're no longer a member of the company? The starting point is tough. That's and it's a very difficult point, and it really can't be what Parliament intended. Now, there are ways around it. Certainly, Joffe, the leading book, suggests that the courts can use its case management powers to deal with a situation that where you've got an arguable dispute as to whether or not the party bringing the claim has standing, the court can then allow the claim to stand, so it won't strike it out, pending a hearing, and probably a separate hearing, in relation to whether or not the petitioner actually has standing. The other approaches would be to seek a declaration from the court, possibly under Part 8, but more likely under Part 7, to say that they are still the owner of the shares, and essentially setting aside any transaction as unlawful. That may be difficult, but it can be tied in with the petition itself. And the other thing that can be done as well is that where you have other claims, and very often there may be contractual claims under shareholder agreements, a personal claim under the Articles of Association, or potentially, as I mentioned, employment claims, but High Court employment claims for wrongful dismissal, that you could issue a claim, and within that claim, ask for a declaration that the shares be, or an order that the shares be transferred back to you, or alternatively, and perhaps more aggressively, say that the loss as a consequence of breach of contract is the loss of the value of shares, where the breach has deprived you of your right to bring a 994 petition. Matthew has asked a question: if a shareholder has not been entered into the register of members by error, if a shareholder has not been entered into the share by error, deliberately or otherwise, of the company, are they a member for the purposes of Section 994? That's a very good question. I think the answer is yes. I think in principle, if they are listed as a member, even though there was no intention, they are a member. I think what would happen was there would be a challenge to that, and what the company could do is seek an order to remedy, to remedy that and amend the register to remove the person. So I think if a person who had acquired shares in that way brought a petition, there would be a fairly rapid way of preventing them from carrying on with the petition. So moving on, what about minority shares? Is it just minority shareholders? Well, the answer is, in principle, yes, subject to 50-50 shareholders can petition, and very commonly do. I would say a very good number of the claims I deal with involve 50-50 petitions. But importantly, it's not a requirement. There's nothing in the Unfair Prejudice legislation in Section 994 or elsewhere which suggests that somebody with more than 50% of the shares could not bring a petition. And the answer is it's difficult, but yeah, and you need exceptional circumstances. So I've given some examples there. A situation where a majority shareholder doesn't have control. That can be in situations where there are different classes of shares with different voting rights. You might be a majority shareholder, but one of the minority may have enhanced voting rights. Also, there may be restrictions on how shares can be used and what votes can be done under shareholder agreements where you don't have the right to just remove it. But the core principle here, and it's a really important principle to remember when you're advising potential petitioners, is that if the acts that you're complaining of could be remedied by the shareholders themselves, usually through an ordinary resolution, perhaps removing the existing board members and so forth, that cannot be unfair prejudice because you're not unfairly prejudiced by things you can correct yourself. As I've said, it's not a statutory prohibition and the test is factual. So what you need to do is when you're looking at one of these situations, you just need to take a step back and say, is this something? Is there another way in which we could deal with this? I've certainly had situations where I've advised in situations where there are other ways. One of the situations I dealt with was where some of the prejudice emanated from problems with a parent company in another country. And the situation there was that there was an option to litigate in that company. The country was Italy, and deal with it at that level. Now, it wasn't necessarily the case that if we did litigate in Italy that we would win, but it was obviously an answer to the petition. Well, all you've got to do is go to Italy and bring a claim. Now, we did go to Italy. For those of you who were used to litigating in Italy, it took a long time because delays in the Italian court system are significant. And what happened was we eventually won, but of course the respondent ignored the decision of the Italian court. So we then came back and we were free to litigate under 994 because we had headed off the argument that we could have solved this prejudice ourselves. So moving on, that's who can petition. What is it we're complaining about? And the phrase that we're looking at is management of the affairs of the company. Now, I said early on that, going back to the 1948 legislation and all the way through, the position has been that the legislature has chosen very broad language. That language is intended to provide a realistic, and I would say commercial remedy in situations where there is unfairness. And I've cited out the words there, anything that the company does or fails to do can be relied upon, from the well-known case of Unisoft Limited in 1994. The points in the boxes either side are important things to remember. The acts of the board and the directors themselves are usually acts of the company. Obviously, a director has other capacities. So if a director is deciding how to vote with his or her own shares, that wouldn't be an act of the company. But when a director is voting on a resolution in a board meeting, or where a director is simply acting in his day-to-day role, managing the company, those actions will normally be acts of the company. And ordinary and special resolutions are also acts of the company. Conversely, acts of members in that capacity are not acts of the company. So, as I've just said, where you have a member that's deciding to decide how to sell their shares, perhaps if they sell their shares in breach of the terms of a shareholders agreement, whilst that may be a breach of the shareholders agreement, in principle, that won't be an act of the company. And then going on, as I've said, a breach of a shareholder agreement or any other agreement will not necessarily be an act of the company. It's also the case that very often other parties can be involved. So a very common situation is where two investors get together, start a company, one of them decides they want to go into competition and incorporates a new co. Very often new co can be brought in, and new co's involvement in the management affairs of the company is something that would allow it to be joined as respondent, and indeed it should be joined as respondent in those circumstances. And we'll look at that in more detail in due course. Dealing briefly with the situation with subsidiaries. To put it shortly, the acts of the acts committed by a parent can also be the acts of a subsidiary and vice versa. I dealt with it, that can be traced through a chain of companies. I dealt with a case, TTP, a couple of years ago, in which we were dealing with two investors who invested through companies who held 50% each shares in a holding company, which then held an LLP, which then held the active company. And at each level, the acts of the directors and the shareholders were acts which then impacted on the next company down the chain. So it's fairly easy to trace through that. I've set out some of the authority there, but it's not controversial to say that you can go from parent companies to subsidiaries and subsidiaries of subsidiaries and so on. And I set out at the bottom there the well-known quote from Dernicourt, which is conduct of the affairs of a parent company include refraining from procuring a subsidiary to do something or condoning by an action the acts of a subsidiary, particularly when the directors of the parent and subsidiary are the same. And that management, that having common directors is an important point when considering whether or not the acts of a parent or a subsidiary impact on the other company. So the million-dollar question, what is unfair prejudice? Well, essentially, it's prejudice that's unfair. And what I've set out there is akin to what I said earlier, which is there are two distinct situations. You can have prejudice which is unfair. You can also have unfairness which isn't prejudicial. Now, I've set out two cases there. I'll talk briefly about Rock Nominee just as an illustration. Rock Nominee was a company which held shares in other companies owned by a Tory peer. The complaint was that the Rock Nominee sold some shares in that company, and the surrounding circumstances really were that the directors had a clear conflict of interest, and so there was an argument the courts agreed with that the directors had breached their fiduciary duties, and the shareholder brought an unfair prejudice petition, and Mr. Justice Peter Smith found that whilst there were clearly breaches of fiduciary duty and clearly there were conflicts of interest, and as such there was unfairness, there was no prejudice, because on the basis of the expert evidence that was before the court, the price that was achieved for the shares was the best that could reasonably be achieved. And that went on, and the Court of Appeal agreed with Peter Smith. And that's essentially an example of that sort of case. I also, the case I mentioned, TTP earlier, we had a situation where on one point we were found that we'd been treated unfairly, but again, weren't prejudiced. So again, something to be careful of, because it's, apart from anything else, it's a particularly annoying way to lose our point. What's meant by prejudice? Well, prejudice is simple, really. At the top level, in most cases, prejudice is economic. And what it means is that there is a diminution in the value of the shareholding of the petitioner. And as we'll see, the way that's normally dealt with is that the minority petitioner normally requests, not always, but normally requests that the majority buy out their shares. And the diminution can be dealt with by the valuers, and we'll talk about this in more detail, allowing for any unlawful conduct and making assumptions to remedy that conduct. But it's not always the case. There are circumstances, particularly in relation to claims for exclusion from management, where there can be prejudice to somebody, even though it hasn't impacted on the value of their shares. So, for example, if somebody has a very clear personal interest in a product and they are marketing that product, their exclusion can be detrimental and prejudicial in respect of their exclusion from the ability to market a product, maybe one that they've designed, and we'll see with Konomi, that's very similar as well, without there being an impact on the shares, because the product's still good, it can still be sold, and the company will have the same value. But as I've said, the usual claim is normally that the shares have been diminished. Unfairness, and I'm going to move on a bit more quickly because I just looked at the time. The leading case on this, and a very important case to consider in any event, is O'Neill and Phillips, which is a judgment of Lord Hoffman back in 1999, and the only case to have reached the House of Lords. Essentially, I think it's quite important to consider this. You've got two basic rules. In fact, you've got two rules. I've called one of the basic rules, so we won't duplicate. The first is a breach of the terms on which the company's been agreed. So articles of association, and usually shareholder agreements, but also there can be other agreements. And very often when you see pleadings, people will plead as to fundamental understandings. So that's the basic rule, which is very straightforward. It's the breach of the rules. The second is equitable consideration, and they are taken at the time of commencement, and they make it unfair for those controlling the company to rely on their legal powers. Now this feeds into, we'll talk about quasi-partnerships, but if you think of a continuum, that at one end, you've got PLCs and large, big companies. At the other end, you have the sort of classic two-person family company. Essentially, it's very hard to bring 994 petitions in large PLCs, because the only way you can really bring petitions is if they go out and just willfully breach their articles of association, and often other things will happen. At the other end, where you've got the two-person brother and sister family company, all sorts of equitable principles will apply, and you will be looking to see that everything they do is conscionable, it's in good faith, and so forth. The important thing to point, and the reason I talk about a continuum, is it's not a straightforward question. It's not quasi-partnership, no quasi-partnership. I think people get very confused about this, and I certainly speak to people who think that unless you can say quasi-partnership, you don't have a remedy. You do. But it is a continuum, and the more personal the relationship and so forth, and we'll look at that now, the better the chance you've got of arguing for equitable principles, but that you don't necessarily need equitable principles if there's been a breach of expressly agreed terms on which companies will be operated. And again, moving on, the test is objective. There is an ongoing concern. If you look at lots of the authorities, there's a bit of a concern that this doesn't just become a free-for-all, and that we just end up with principles of fairness, which are fairly unrestricted. And in O'Neill and Phillips, Lord Hoffman made the point that these notions must be applied judicially. And that's really based on the traditional way in which chancery courts apply equitable principles, and that's where the basis comes from. A good summary is Grace and Biagioli, and they're the principles in Grace and Biagioli. As I've said, unfairness is subjective. It's not usually unfair. It can be to conduct a company in accordance with articles and other legally enforceable documents. As I've said, the further you get down that spectrum towards pure family or personally motivated companies, the more chance you have of saying that operating the company in accordance with the articles or other agreements can still be unfair prejudice. The equitable principles will be applied in accordance with established equitable principles, so it's not a free-for-all to just go along and say, but it's unfair. To be unfair, it need not just justify winding up on just an equitable grounds. I'm not talking about just an equitable winding up. That is possible through a petition. It's frowned upon, and normally there is value in the company when you have a 994 petition, and so courts rarely want to wind up viable companies. And then I set out the useful, the useful test. You go back, sorry. At the bottom, I apologize, I was having difficulty with it because I have a bar from Zoom across the words. But that's a very useful test, and that comes from Grace and Biagioli. There are some examples of unfairness. Exclusion from management is by far the most common in my experience. I think almost every petition I've done involves exclusion from management. Breach of fiduciary duties, hold the thought on breach of fiduciary duties, just the extent to which they are things which are remediable in a petition rather than a derivative claim. And I won't go through the others, you can see them all there. Misappropriation of assets by directors and excessive remuneration is also, I would say, the second most common, and they often go hand in hand with exclusion from management. I mean, essentially what you have, a lot of people talk about corporate divorce, and that's very often what you have. People fall out, directors of a small company fall out, there's then an exclusion, somebody starts paying themselves a lot of money, and then they form a new co and start moving out assets. And that's a classic situation, and one we'll see when we get to Koinomi. Quasi-partnership I've spoken about. This has its origins in Ibrahimi and Westbourne galleries. In that, Lord Wilberforce set out these three characteristics of a company, and if a company exhibits one or more of these characteristics, it may be a quasi-partnership, although it's not necessarily a quasi-partnership. As I've said, I wouldn't get overly worried about quasi-partnership, because in many respects, I think the problem with quasi-partnership is we sometimes think that it's the be-all or end-all, and it's not. But as I said, there is, as I've talked about, a continuum. And if you case of quasi-partnership very much at this end, it doesn't mean that because you can't fall into this that you don't have a remedy. You may well still have a remedy. But if you can plead quasi-partnership, it's always a good thing, because it means that your position is much more flexible. And I've said at the bottom there, it's important to know, quasi-partnership, it's just shorthand. It's shorthand for saying that you're in a company that can attract equitable principles. Now, that's why you have to consider it to be a flexible, because it can be that without being able to say it is a fully fledged quasi-partnership, it may be that you could import equitable considerations much further down the continuum towards the larger companies and the PLCs. And the list is non-exclusive, so you can imagine lots of situations, a situation in which investors invest on a non-commercial basis would suggest quasi-partnership, and lots of other things where people do things for personal reasons. Relief, as I've said, section 996 is deliberately broad. And so the court has, realistically, if you look at the authorities, the court regularly make it clear they can do pretty much anything they want. And when we look at Coinomi in a second, you'll see that the versatility there allows the court to do things, including granting relief that might otherwise have been available in a derivative claim on behalf of the company. The other thing to say is injunctions are very often possible. I've certainly sought a number of injunctions in unfair prejudice claims, normally to restrain companies from carrying on with doing or not doing a certain act. Sometimes it's important to note that when you issue a petition, the respondents cannot use the company's money to defend that petition. And I've certainly had a couple of occasions when we've gone to court to get an injunction to prevent respondents using company money to defend the petition. When it comes to injunctions, the thing to be wary of is that certainly when you go before a judge, and certainly a Chartered Division judge, they do not want to be in a situation where the court ends up managing the company. And if you get to a situation where things are that bad, and say very often they are, because you quite commonly have 50-50 deadlock companies, the answer then may well be to appoint an administrator. There's always the downside of appointing administrators, that it's expensive and cumbersome. But certainly I've had situations where we've done it because there really is no other choice. Because if you've got two parties, particularly when, as not entirely uncommonly, there are allegations of dishonesty or certainly very serious misconduct, the only way to hold the ring, as the courts like to describe it, is to do something by appointing an administrator or having very strict injunctive relief. As I've said at the bottom there, I alluded to earlier, the most common order is for the majority to buy out the minority at a price determined by an expert. Madeline asked what remedies do beneficial owners have in respect of unfair prejudice claims. I'd say in principle, beneficial owners don't have standing to bring a claim. There are other possibilities. If they are beneficial owners and they have 100% right to the assets, they could demand transfer of the title and get themselves registered. As I said earlier, if it's under a trust, there is a possibility of bringing it as a derivative claim under the trust by joining the trustee. But if you're a pure beneficial owner, what you need to do is compel whoever has the legal title. But other than that, you just don't have standing under Section 994 petition. Valuation, very briefly, the two key points really, one is generally, and it is only generally, there's no minority discount, and that's really Bird Precision. In O'Neill and Phillips, Lord Hoffman gave an example. So for example, where somebody has suffered unfair prejudice, but their exclusion for the company was in part motivated by their own bad behaviour, so sort of kind of clean hands type argument. It may be in those cases that the court does apply a minority discount, but by and large, you will always say no minority discount. And the date of valuation is generally the date of the order. That's very variable, because very often you'll be in a situation where you can pin the date at which the respondent started acting unlawfully to a certain date. And very often you will ask the date to be at that date, so that the detriment to the company caused by the unfair prejudice didn't kick in. Methods of valuation, I think everybody's familiar with those. And then finally, adjustments of valuation can be made to allow for prejudicial conduct. So if they've sold an asset with huge undervalue to a related company, you can just simply bill the value back in. And I said at the bottom there, that's just my own practical experience. Getting an expert on very early is a good idea. So moving on to Koinomi, and I'm very aware of the time. Koinomi is a classic 994, and this was a decision of the Court of Appeal from last week. Koinomi Limited is an English company. The petitioner and the respondent held 50-50 shares, and they had developed a multi-chain crypto wallet. And this is going back to between 2013 and 2019. So at a time when crypto was very much the next big thing. What happened was that eventually the respondent incorporated a company, Koinomi Cyprus, and then basically transferred the IP and things like the domain name and also the accounts with the app stores from Koinomi Limited to Koinomi Cyprus. And then he formed Koinomi BVI and licensed that company to use the IP that was now held by Cyprus. The important parts here is that in his claim, the petitioner claimed that the Cyprus and BVI companies were liable to the English company for knowing receipt, and that all the assets that essentially Cyprus had received, and probably the benefit of the license held by BVI, were held on trust, and or that Cyprus and BVI had knowingly assisted the respondent in his breach of fiduciary duty. The relief claimed, which is where it gets interesting, was first an order for the respondent to sell his shares to the petitioner. Note that's the other way round from the usual approach. An order for compensation to the company in respect to its losses, and a declaration that the assets held by the Cyprus company and the BVI company were held on trust. Now, there's nothing surprising in those remedies themselves, but of course, the main question is whether or not loss that appears to be suffered by the company can be claimed by a petitioner on a 994 claim. And that's the primary question. And I think everybody's familiar with Foss and Harbottle, the proper plaintiff rule, or proper claimant rule. And the question for the court really is allowing a petitioner the ability to claim amounts which are, on the face of it, claims that the company could make, subverting the Foss and Harbottle proper claimant rule. And did the petitioner require permission of the court under Section 260 of the Companies Act 2006? And I'm sure most of you know Section 260 of the Companies Act is Part 11, which is the derivative claim section. So looking at the moment, it's a classic unfair prejudice claim. There's the significant points for exclusion from management and misappropriation of assets. The thing to notice about this case is, in reality, it's an IP dispute. And I say that because it's a case where the petitioner didn't want to sell his shares to the majority. He wanted to buy their shares, but he also wanted the company to have all the IP back, because obviously what he wants is to trade that IP and use the company to make profits. Now, in terms of the defence that was advanced was the respondent said that the petitioner was only ever a contractor and that he carried out the work in creating the wallet as a contractor for the company. Now, for the IP people, I know there are all sorts of problems with that defence, but it was a strikeout application, so the court, neither at first instance nor in appeal, went on to it. I think the problem started first instance. At first instance, the judge set out what he thought to be the question of principle, whether the petitioner ought to be permitted to proceed to trial on the petition in respect of matters which could have been litigated against the respondents by way of derivative claim, and whether this outflanked the limitations in Part 11. That's problematic because there's nothing in principle. If you look at the legislation, there's nothing in 260 that says that if something potentially falls within the definition to 260, which we'll look at briefly, that it can't also be subject to a 994 claim. I think the question the judge asked himself really wasn't the question he should have been asking. But I think where the judge was perhaps led astray was that the argument before him was that he should adopt or certainly follow the law in the Reed Chime Corporation case, which is a Hong Kong case. And what the Hong Kong case said was that you can bring what would otherwise be a derivative claim in an unfair prejudice claim in rare and exceptional cases. Then went on to say the only test was whether a claim can be conveniently adjudicated within the unfair prejudice proceedings. Applying that, he decided that the two claims, the claim for compensation and the claim for trust, couldn't be conveniently adjudicated. Now that's, I think, surprising anyway, because there are lots of times when you're dealing with a 994 claim when obviously claims which are claims the company can bring are in there. And certainly as a matter of commerciality, it would be much more sensible to deal with those in one set of proceedings. And it's not at all unusual to have a Part 7 derivative claim running alongside a petition and to have them managed together and tried together. The Court of Appeal's approach was, now this requires, there's two limbs to whether or not a derivative claim should be brought, and they're in two sections, 61A and B of the Companies Act. A is whether the claims in respect to the cause of action vested in the company, and B is whether the person is seeking relief on behalf of the company. And focus on the on behalf of the company, because I think that's where things happened. The majority of the court, which was Mr. Justice Newey and Lord Justice Newey and Lady Justice Whipple, held that it did fall foul of 261A because it was a claim in respect of cause of action vested in the company. But it didn't fall foul of 261B because the petitioner wasn't seeking relief on behalf of the company. Lord Justice Snowden disagreed. Now, it didn't matter because those two parts of 260 are cumulative. So if you fail on one, then it's not a derivative claim. But Lord Justice Snowden looked at the Chapter 11 and looked at the intention behind Chapter 11, the derivative claims and Section 994, and made the point that the Law Commission, when they were considering these, said that parties should have the right to choose between them. And the question is the question at the bottom there, that if the relief is sought independently under 994, which is what Lord Justice Newey said at paragraph 38, how can it be said in respect of the cause of action vested in the company? Given the time, I won't go through these points, but Lord Justice Newey set out these 6 points, and you could have the slides. But just to bring things to a close, the important point is that Lord Justice Newey found that the court has established jurisdiction to grant relief in favour of the company in a 994 petition. And importantly, they shouldn't generally grant that unless the company would have independently been entitled to it. So again, mindful of time, the points I think that need to be raised are this. I don't think Koinomi is a particularly surprising decision. And I think it's obviously sensible that in a situation where you have a claim like this, that the court should be able to bring it. Under Section 996, the court can authorise a derivative claim, but it's not obvious why they should need it to. Now, the first point to say is that this is really only going to be applicable in situations where a respondent seeks to buy the shares from the petitioner, because the other way around, as I've said, this problem could be dealt with by adjusting the valuation. But in this situation where a petitioner wants to buy the shares, so he or she essentially gets the company back, they may also want the assets back, or they want the company compensated. And this is where they may want to bring this claim. Now, certainly in my view, if the court has jurisdiction to grant the relief, and the claim is made under a 994 petition in the name of the member, how can it be said that it's a claim in respect of cause of action vested in the company? Because under 994, in most circumstances, the company can't have a cause of action because it won't be a shareholder. So if we're looking at a situation where the only jurisdiction the court has to grant any relief is Section 994, and we accept, as Lord Justice Newey did, that the court has the jurisdiction to grant that relief, it's very difficult to see how you can say that the petitioner was bringing a claim that was bringing a claim on a cause of action that was vested in the company. I also put at the end there just to consider the traditional distinction that's made by Lord Millett between mismanagement of the company, which is generally seen to sound in unfair prejudice, and claims for a remedy for misconduct, which is derivative claims. I think when you look at this, what you're seeing is that versatility in the unfair prejudice rules is actually seeing itself come to fruition, because where you're getting to now is a situation where it's so broad that you can bring in these losses, providing they're losses for which the court can grant relief under Section 994. So essentially, one, does the petitioner have standing under 994? Yes. Does the court have jurisdiction under 996 to grant the relief sought? Yes. Would the company be able to get that relief independently if it brought a derivative, or if a derivative claim was brought on its behalf using its different cause of action? Yes. On those circumstances, in a claim, you should be, sorry, 994 petition, there's no reason why you shouldn't be able to recover it. And I think what we'll see, I wouldn't be surprised if this claim goes to the Supreme Court. I hope it does, because it'll be interesting, and we don't often see these sorts of cases there. So that's the end of the talk. Thank you all for attending, and thank you for listening to me, and I hope you all have a very happy Christmas and a very prosperous New Year.